Court calls the people of the state of Michigan versus Philip Andrew Liefers, case number 26819FY. Appearances, counsel.
Please roll for the people.
Good afternoon, Your Honor. Bernard Jockins appearing on behalf of the defendant, Philip Liefers.
So are you Mr. Leffers?
Are we on the record, Your Honor?
We are. Are you Mr. Leffers? Is it Leffers or Liefers?
I am Philip Andrew Liefers. Being duly sworn, hereby declare my intentions to be a Michiganian national by birth, but not a citizen of the United States. I am here on special appearance in this case as authorized representative, beneficiary of the estate of Philip Andrew Liefers. I appear before this court without waiving any rights, claims, defenses, or remedies available to me at law, equity, or under trust or fiduciary law. I have my CPAS.
We can't really hear you.
Sir, can I get you to speak up so that
Yes,
so that we can get a
sir.
clear record?
I have my CPAS. And I have been working very hard to understand and overstand a lot of things in the past. No disrespect, just complete forwardness. I move the court to take judicial notice of the Michigan Constitution of 1850 and the United States Constitution of 1788. And your oath to it, sir.
The yes or no to what?
This is a copy of your oath of office, sir.
I'm going to take anything until judge tells me to.
Bailiff, I'll take it.
Yes, sir.
Yes, that is my oath of office and has my signature on it from January 22nd, 2025. You can hand that back to him.
I move the court to dismiss this case per canon 2057, which states any administrator or executor that refuses to immediately dissolve a Sesta QB trust upon a person establishing their status and competency is guilty of fraud and fundamental breach of their fiduciary duties, requiring their immediate removal and punishment. Per the United States Constitution, Article 3, Section 2, Clause 2 clearly states that when the state is a party, whether defendant or prosecutor, the Supreme Court has original jurisdiction. Supreme Court decision 1796. There, every man is independent of all laws, except those prescribed by nature. He is not bound by any institutions formed by his fellow man without his consent. Pruden v. Neely, 2 NC 338, 1796. And don't forget the law of the land, where the general misconception is that any statute passed by legislatures bearing the appearance of law constitutes the law of the land. The U.S. Constitution is the supreme law of the land. And any statute to be valid must be in agreement. It is impossible for a law which violates the Constitution to be valid. This is succinctly stated as follows. All laws which are repugnant to the Constitution are null and void. Marbury versus Madison, 5 U.S. 2 Cronch 137, 174, 176, and 1803.
There's this sweet little irony to sovereign citizens citing both Article 2, Section 2, Clause 3 of the U.S. Constitution and Marbury v. Madison in the same argument, as 223 of the Constitution delegates the powers of the Supreme Court, and Marbury v. Madison reinforced those powers. Basically, the Supreme Court has appellate court powers and only has trial court powers as the court of original jurisdiction when public ministers as ambassadors and civil cases where the state is a party. In fact, Chief Justice Marshall ruled that the Supreme Court's powers as dictated by the U.S. Constitution is a ceiling and not a floor for hearing cases, meaning that the case that he cited is exactly why he's in state court and not the Supreme Court of the United States.
Where rights secured by the Constitution are involved, there can be no rule-making or legislation which would abrogate them. Miranda versus Arizona, 384 U.S. 436, page 491. The United States Supreme Court has repetitively held that any judge who acts without jurisdiction is engaged in an act of treason. U.S. versus Will, 499, U.S. 200, 216, S period CT period 471, 66 L edition 2B 392, 406 in 1980. I, Cohen versus Virginia, 19 U.S. 6 Wheat, 264, 404, 5L edition 257, 1821. 5 U.S.C. 556D, 557 and 706. Once due process is denied, all jurisdiction ceases. Due process has not been properly followed on me. I have not been given full disclosure of everything, including the accounting information, the bid bond, the performance bond, the payment bond, all accounting involved in this, as well as I have not been given the almost 1 hour video of the security footage from Save-A-Lot. Only 14 seconds is what I was informed from Mr. Jockins. And when I asked him for it, he denied me access to it. So I am not being given a fair shot. So I have removed him as my counsel.
Judge, I can't see Mr. Lepers in there. I don't know if the court wanted me to respond.
Sure, let me adjust the camera. I'm sorry for that.
Your Honor, I'm just going to back up and give a little bit of procedural history to the court. I know that the court always reviews the files. I'm just going to explain where I'm at. When I was initially assigned counsel on this case, I took the time and opportunity to review Mr. Lepers and consult with Mr. Lepers, not in person, but I did. With that information that was provided to me and speaking with other witnesses, family members, potentially, I decided it was appropriate to file a motion for a competency evaluation and inevitably criminal responsibility in this action. And the court could take notice to the Mr. Lepers' remarks, motion, etc. Judge, I provide everything to Mr. Lepers, as I do for all of my clients. And I do follow the Michigan Constitution, the United States Constitution, and every case I have is as important as anything that is going on. With that in mind, Judge, I got notice of this. It was supposed to be, I believe, on the 7th or 8th of April, and I had contacted the clerk indicating that I didn't think that it was appropriate at that time because we still do not have the evaluation that was returned from the MDHHS regarding the forensic evaluation. And maybe the court can understand the reason why I requested this evaluation, regardless if something was like a ChatGPT sovereign motion. If the court wishes to remove me, I am fine with that. If somebody doesn't want me to represent them, that's fine. But at the same time, I meet all of my obligations and do everything that I am supposed to do with each client, even more so.
Yeah, I don't blame his lawyer for wanting to run away as fast as possible from the sovereign citizen's superglue buffet.
So, with that in mind, Judge, the only concern that I have is that we're still waiting on a forensic evaluation that Mr. excuse me, that Mr. Leffers had participated in approximately a calendar week back.
We got the motion for him, but order.
Yeah,
What did I do a calendar week back?
I don't show where I mean, I see where, at least I can't put my hands on it now, but I remember you filing a motion. But I have not signed an order for a competency evaluation yet.
Well, with that in mind,
Because-
Judge, I don't know what the court would like to do. If the court would like me to get, I thought that I had provided a competency order, SCAO form. If not, Your Honor, I'm fine with Mr. Leffers proceeding on his own.
Your Honor, I
Hold
object.
hold on. Yeah, so I show that there was a motion filed by Mr. Jawkins on March 23rd for motion for evaluation of defendant's competency to stand trial. And actually, I believe it was that same day we received the defendant's motion, Mr. Leffers' notice of self-representation and motion to withdraw. And then the next day, we received an updated copy of that notice of self-representation and motion to withdraw. So I believe this is the first time we're here since these have been filed. And it's generally the court's practice to have a hearing before just granting a competency request. So that was one of the reasons we were here today. So we were actually set for a preliminary examination and these motions. So I believe it obviously is not appropriate to do the prelim today. And so that gets us to the motions. So I guess, Mr. Jawkins, I'm going to turn to you quickly. Your take on the situation. I know you said that you are okay withdrawing, but do you believe that there has been such a breakdown as to require you to withdraw?
Your Honor, I cannot communicate with this individual, and my apologies. When I had communicated with the clerk's office, I was it was indicated that the exam was taken off the docket, and that might have been an email thread as well. So I hope the court doesn't think I'm being deliberately derelict or anything like that. But
Oh no,
these are the reasons why I filed this motion, Judge. But if Mr. Levers would like to proceed on his own, I'm not interested in. I'm the captain of everyone's ship, and I leave it at that. I really, I don't have a good feeling about that when someone files a motion to withdraw, and if I am out there. However, I still think it's appropriate for a competency evaluation. That's the reason why I had filed that, Judge.
all right. Thank you. Now, Mr. It's Leffers or Leafers? I know you said and I apologize.
No,
So I want to make sure that I'm following your request. And I understand that you have some arguments as to, one, whether or not the court has lawful jurisdiction, lawful authority, and also a question of whether or not you have been provided with appropriate due process. Couple that with is your request to represent yourself. Am I correct on that?
yes,
All right. And are you requesting to represent yourself?
yes,
You do understand that you have the right to have an attorney that either you could hire or that the court would appoint, as opposed to you representing yourself. Do you understand that?
yes. My creator has placed a lot of friends around me with wonderful information that I never knew. And I'm grateful to know this now. I'm sorry or being caught in dishonor in the past, it will not, happen again.
Well, apparently, it's already happened again. Allegedly.
I understand my place, and I have always tried to respect the way that things are, which is why I need to finish this as well, sir, please.
Go ahead.
And with discovery not being met, there are no medical records, let alone a psych evaluation proving any type of trauma. No harm has been done. No pain has been inflicted and no property was damaged. I have entertained the contract deal of alcohol testing, and I don't drink anymore. And yeah, that was an issue. Not anymore. But in the same token, I can no longer contract with it, knowing that everything's a contract. As you can see from the tests, I even stopped smoking weed and only smoked it right before bed. Since the motorcycle wreck, things have been very uneasy trying to sleep at night. Period. Definition of presumption. An idea that is taken to be true on the basis of probability. As a presumption is a presumption on which must be agreed by the parties to be true. Then, and equally, if one party challenges the presumption to be true on the basis of probability, then all that is required to remove the presumption is a formal challenge. That presumption, the presumption, then has no standing or merit in fact. Probability. The extent to which something is probable, the likelihood of something happening in a case. By definition, then, this is not substantive, as it is only a probability of what may be, and therefore has no substance in marital fact. An incorporated state court does not operate according to any true rule of law, but by presumption, color of the law. Therefore, if presumptions presented by the private bar guild are not rebutted, they become fact, are therefore said to stand true. There are 12 key presumptions asserted by the private bar guilds, which, if unchallenged, stand true, being public record, public service, public oath, immunity, summons, custody, court of guardians, court of trustees, government as executor, beneficiary, agent and agency, incompetence and guilt. Section I. The presumption of public record is that any matter brought before a state court is a matter for the public record, when in fact it is presumed by the members of the private bar guild that the matter is private bar guild business matter, unless stating openly rebuked and rejected by stating clearly the matter is to be on the public record. The matter remains a private bar guild matter completely under private bar guild rules. I, Philip-Andrew Leifert, is the undersigned formally challenge the presumption of public record, as it is by definition a presumption and by definition has no standing or merit in presentable or marital fact. Section 2I. The presumption of public service is that all the members of the private bar guild who have all sworn a solemn, secret, absolute oath to their guild then act as public agents of the government or public officials by making additional oaths of public office that openly and deliberately contradict their private superior oaths to their own guild. Unless openly rebuked and rejected, the claim stands that these private bar guild members are legitimate public servants and therefore trustees under public oath.
Well, apparently it's already happened again, allegedly.
I am back in place. I do not need a trustee over my estate. Will govern as my creator wants me to. I, Philip-Andrew Leafers, the undersigned, formally challenge the presumption of public service as it is by definition a presumption, and by definition has no standing or merit in presentable or marital fact. Section 3I. The presumption of public oath is that all members of the private bar guild acting in the capacity of public officials who have sworn a solemn public oath remain bound by that oath, and therefore bound to serve honestly, impartiality, and fairly as dictated by their oath. Unless openly challenged and demanded, the presumption stands that the private bar guild members have functioned under their public oath in contradiction to their guild oath. If challenged, such individuals must recuse themselves as having a conflict of interest and cannot possibly stand under a public oath. I, Philip-Andrew Leafers, the undersigned, formally challenge the presumption of public oath as it is by definition a presumption, and by definition has no standing or merit in presentable or marital fact. IV. The presumption of immunity is that key members of the private bar guild, in the capacity of public officials acting as judges, prosecutors, and magistrates who have sworn a solemn public oath in good faith, are immune from personal claims of injury and liability, unless openly challenged, and their oath demands, as it is here, the presumption stands that the members of the private bar guild as public trustees, acting as judges, prosecutors, and magistrates, are immune from any personal accountability for their actions. I, Philip-Andrew Leafers, the undersigned, formally challenge the presumption of immunity as it is by definition a presumption, and by definition has no standing or merit in presentable or marital fact. B. The presumption of summons is that by custom and summons, unrebutted stands, and therefore one who attends court is presumed to accept a position, defendant, juror, or witness. In jurisdiction of the court, attendance to court is usually invitation by summons, unless the summons is rejected and returned with a copy of the rejection filed prior to choosing to visit or attend. Jurisdiction and position as the accused and the existence of guilt stands. I, Philip, Andrew, sorry. Short-term memory was wiped out in coma. I, Philip-Andrew Leafers, the undersigned, formally challenge the presumption of summons as it is by definition a presumption, and by definition has no standing or merit in presentable or marital fact. Section B.I. The presumption of custody is that by custom and summons or warrant or arrest, unrebutted stands, and therefore one who attends court is presumed to be a
Judge, I'm sorry, I'm objecting at this point.
And
right now, there's nothing that's relevant. This is just rambling and rambling and rambling. Chat GBT, sovereign citizen stuff.
You know, you seem to know a lot about this secret oath they took. Either it's not really a secret, which it's not, or you're clueless to what you're talking about, which you are. And both can be true at the same time.
All right, thank you. Now, sir, that I know you have a lot to get out there. One of the things that I have to be concerned with is if you are to represent yourself, that you, one, have the understanding of the court rules and procedure. Now, I know, and admittedly, it's been a while since I've seen this type of material out there, but I have seen it, and I'm familiar with the position that you have. And I understand that you are essentially challenging the authority that one, I have as the judge, two, that this court in totality has, and three, anything that any charges that the prosecutor might have. I can tell you that based on what I'm hearing today, I'm not going to allow you to represent yourself. I don't think, while I understand that those are your beliefs and your feelings, I don't think that represents a true grasp of the reality of how this republic works, how this state works, and how the court works. And so for you to represent yourself, I think is going to potentially do more harm than good for you. So what I'm going to do, as you've heard, I've allowed Mr. Jockins out of the case. But what I'm going to do is I'm going to make another referral to another attorney for you. All right. It's not that I don't think that you're smart enough to handle the case. That's not it at all. There's some procedural issues here that I don't think you quite grasp how it works. And that is, I'm going to be honest, will probably go to your detriment. And and you've got some pretty serious charges here. One of them is a 4-year felony. Means, you could have up to 4 years in prison. So I want to make sure that you have the appropriate legal representation. And for that, I'm going to deny the request for you to be able to represent yourself. So we'll make another referral to the public defender's office. It might take a little bit of time because for whatever reason, this case went to a conflict attorney, which tells me that the public defender's office has some sort of conflict. What that conflict is, I don't know. But that's how Mr. Jockins came in, is he's a conflict attorney that they work with. So they'll have to reach out and find another attorney for you. Okay.
Your Honor.
Yes.
I move the court to dismiss all charges at the same time. This was case number 26-891-SN-1, which came to fruition because of these false charges that have been placed upon me.
So,
And had the officers actually done their due diligence and looked at the video footage, which is almost an hour long, proving I never ran anyone over, never threatened to, so no harm was done. Everything should have stopped right then.
It's about time someone told him to shut up. You'd think it'd be the judge, who I don't really think is at fault here. But no, it's his attorney of record who's objecting to his client doing any more self-harm than he's already done. No wonder he wanted a competency evaluation.
So there's a procedure in which to do that, and there's a proper hearing at which to request a dismissal of the case. That is not today. There's a proper time and place to do that. For what we're here for today, that's not it. I say I can't tell you what that date is or what the procedure is, because that would be giving legal advice that I can't give as a judge. which is another reason why I think I shouldn't say why I think, another reason why I believe that you need to have appointed counsel to assist you with that and to evaluate all the potential discovery issues out there that you've brought up, to evaluate your defense, and to direct in a manner which will be a beneficial outcome for you. So what I'm going to do is we'll reset this case for another day. We'll get another attorney appointed for you, and we'll have that attorney get in contact with you, and then you can discuss with them your concerns and the best procedure for moving forward. Okay?
Well, fortunately for you, that's what a trial's for. And if no crime was committed, then the person that you just fired or quit, depending on your perspective, would have been the most capable and qualified person to handle that for you.
There's a problem with that, though. I do know this both sides do. I do now. It goes against the Constitution. Even if you do have conflict. So if you want to push this to the Supreme Court, I'll go and stand in front of the Supreme Court.
Well,
I'm okay with that.
that's certainly your prerogative to do that. So, and that's why we have the appellate courts in place.
So I need a ruling, sir. Are you going to dismiss these charges on lack of jurisdiction and a violation of my constitutional rights? Article 3, Section 2, Clause 2.
All right, Mr. Leffers, I have found that I'm not allowing you to represent yourself in the court, so it's not appropriate for me to give a ruling today because I'm not allowing you to represent yourself. That is something that an attorney can assist you with. I will state, as I stated before, today is not the proper time to entertain that request for a dismissal.
All right.
All right, so I'll need
Disrespect, sorry.
none taken, none taken.
Learning curve. Learning.
All right, so that's almost the end of the video. The judge is going to find him incompetent to represent himself, as that would put an unconstitutional burden of non-representation on the defendant. Now, he does have another hearing coming up, but before we get out of here today, there was this small exchange between the softard and the judge that needed to be heard in order to be believed. Yeah, I don't think you're supposed to try to enjoy a learning curve in life when a potential 4-year prison sentence is the penalty for failure. That being said, we have reached the end of the video. And like I said, he has a hearing coming up in the future, and I am 100% going to be following up with this human dipstick. So, if you liked the video, hit the like button. If you disliked it, hit the dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content. I'm Team Skeptic, and I'm out.